SJC-13297, Erik, Tenczar et al. Versus Indian Pond Country Club Inc. et al.
Okay, Attorney Nowicki, whenever you're ready.
May it please this honorable court and Chief Justice, my name is John Fleming. I represent the defendant appellant Indian Pond Country Club in this matter. With me at the counsel's table is Attorney Leon Nowicki, who's also with me on the brief. This case is before the court on appeal from a judgment rendered in the Superior Court, which ruled that the developer of a residential golf course community did not have the right pursuant to recorded declarations of covenants and restrictions.
Let me ask you a question. Are you arguing that they have the right to retrieve the balls in the undeveloped part of the land? That's clear, right?
Right.
And are you arguing that they also have the right to retrieve the balls in the developed part, or are you arguing that the balls have a right to go where they went into the house?
Just that the balls have a right to go in there.
Anywhere.
We think the declaration
All right,
is
so let's go to the declaration for a minute. Can you tell me in the, I think it's Declaration 20, I'm not sure, which one do you rely on? Do you rely on the 1990s, were the years, 96 or the 98 for this lot? For the Tenczar's lot?
for which?
The lot in question, the one where the balls are. You've got two declarations, one that's amended.
Correct.
Are we working with the amended or the original one?
We're working with the original one is the one that grants the easement in general terms.
And the original one, when you get to it's clause 20 we're concerned about, right?
Correct.
Okay. So when we get to that clause, there's another, the first sentence has a comma after, as shown on India Pond Estates 4, comma, plan other than those expressly subject to this declaration. What does expressly subject to that declaration cover?
Well, in the earlier section of the declaration, it lists the specific lots that are covered by the original declaration.
And the lot 480 is in that, right?
No.
No, it's not.
It's not.
So it's not at all in there. Not covered by the one that we're dealing with, the amended one.
Oh, it's also, then when it's amended, it's specifically referenced as being covered by that one.
So, okay, so by the, all right, that's what I wanted to know, so by the amended.
Could you summarize that? Because it's not as clearly drafted as it could be. So,
That's what happens.
yeah, well, but we're trying to make sure we understand exactly what the developer reserved, and the last clause is confusing.
Section 20, are you
Why don't
saying?
could you walk us through 20? Because I think, I agree with you that there's, the hard part of the case is not the meaning that golfers can't go into their improved areas. That's dealing with a specific problem. Golfers, they see a ball, they want to retrieve it, and they go further than they're supposed to. And this set a dividing line. We're struggling with the other parts of the declaration, which don't seem to be presented with the jury, but aren't as clear as they could be. Could you just walk us through the exact language on that?
And I think that the factual background of the development to some extent is important on that
Well, yeah,
question.
but we have to deal with the documents first.
Oh, in terms of
don't
interpreting an
skip the
easement
document.
granted in
We're
general
dealing
terms,
with land.
But I think we could, could you just walk us through that clause? Because it, literally,
okay. The declaration
do
is-
section 20 and then the first sentence or two in section 16 that redoes the declaration about how you, what's reserved for the golf
Well,
course.
Section 20 basically says that with respect to the lots that aren't covered by what we've dealt with in 1 through 19, which is like things related to what kind of houses can be built and whether you can have clotheslines in the backyard and other things relating to the common scheme of the development.
Let me be more specific for you. I'm reading exactly from the language. Developer expressly reserves and retains for itself the right to create and operate and maintain a golf course on all portions of the land as shown on the plan, and then we get into this, other than those expressly subjected to this declaration. Is that because at the time 4105 was the only thing expressly dealt with, or what does that mean?
There are 34 lots that are specifically referenced in the declaration.
Right.
And with respect to all lots other than those 34, the developer is retaining the right to construct and operate a golf
And
course.
those 34, because they're further away from the golf course, is that what they're
No,
about?
they're on one side of the development is a big circle.
Yeah.
And when you do a development of this size with 134 lots, you tend to do it in phases. So the developer came in to the entrance, up the entrance to the country club and went around halfway on one side. And the lots that are referenced in there are the lots that are on that one side.
And those lots, so those lots are away from the course in a way that they're not in play, is that what you're saying?
Some of them are.
Okay, so again, this lot is one of those other than those expressly subjected to the declaration
Correct.
at the time. Then in the next declaration, it's included. Is that your view?
Correct. It's
So the-
specifically defined as being a golf course lot for purposes of the amendment.
So that golf course lot is covered by the reasonable and efficient operation of the golf course in a customary and usual manner.
That is our position, yes.
And the judge doesn't allow you to argue that, nor does he allow the jury even to consider that part of the declaration?
That's correct. He
And
told
that's
me I
your
couldn't
view of
argue
what
it.
the error is, right?
Well, it's certainly part of what the error at trial was. We also contend that the interpretation, which is before you on a de novo basis, because the question of what is the meaning of an easement is a question of law. We believe that if you applied the correct legal standard, which has existed in this Commonwealth for over 100 years, in terms of how you analyze an easement granted in general terms, you have to look at all the circumstances, the attendant circumstances surrounding the creation of the easement. And the primary focus is to try to ascertain what the intent of the developer in this particular case was when, after getting approval for a subdivision, getting approval, a special permit for a golf course to be located in the interior, specifically reserving in the recital to the original declaration his intent to create a residential community with a golf course located in the center of it. If you look at all the circumstances, he acquired 1,000 acres of land over more than a decade, got the subdivision approval, got the special permit from the town, hired someone an architect to design the golf course, determined that it was going to cost him $4 million to build the golf course, and he records this document. Right. So is it his intent to give the residential unit owners the right to come in and say, you can't operate the course the way it was designed?
So are you saying that the right to operate the course includes, despite the express restrictive easement, that the right to operate the course includes the balls going into their house?
Correct. Our argument is it's axiomatic.
And looking at the cone, those cones in the exhibits, that if you turn it this way, it's going to go here, and if you shift the tee that way, it'll go there. There's no adjustment that the country club could have made for these owners. Is that right?
We made adjustments. I mean, what the whole idea was, a golf course can't control the mishits of the golfers who are playing the course.
Right, but we still have Massachusetts restrictive covenants, and you said we have 100 years worth of law, so why aren't our cases better than the Georgia case?
This isn't a restrictive covenant.
It isn't?
No, it isn't. It's an easement.
It's an easement. Sorry,
it's not subject to one.
But it's a restrictive, it's an affirmative easement. Would you
It
agree
is.
with that?
I mean, if you want to talk about restrictive covenants that might be subject to the restrictive covenant statute.
Well, it's all the things they can't do.
It's the things that they can't do.
Right.
Exactly, Your Honor.
So forgive me for mixing up the terms, but is this an affirmative easement then?
It is. It's an affirmative easement, just like, to me, and my position has been throughout this trial, that the Commercial Wharf East Condominium Association versus Waterfront Parking Corp case is the closest case that you can have to this. In that particular case, the developer retained the right to control and collect fees for the parking of vehicles.
Can I ask you, because I know the commercial wharf case, and your time is limited. Can I ask you why there wasn't a motion for summary judgment here, given that your argument on appeal appears to be that as a matter of law, looking at these two documents, one can determine that Lot 80 was subject to this easement? Why did this go to trial? What were the material issues, the issues of material fact that needed to be resolved at trial?
Well, again, the interpretive rule, which I think clearly applies in this case, is that you look at these documents in light of what they say, and you try to determine what the intent of the drafter of the document was when he drafted these by looking at the language and considering the attendant circumstances and the facts that were known to the declarant at the time it was issued.
And were those attendant circumstances disputed before trial? Is that why there was no summary judgment? I guess in answer to my question.
I think it was my position that they could be disputed.
Okay.
That's what I'm confused by. Meaning that the golf course wasn't being operated, hole 15 wasn't being operated in a customary and usual way, meaning it was too dangerous to put the house there? I'm just, because again, I have the same question, Justice Wendland. It seems to be a question of law. Do you have the right to put golf balls into their, not just into the, the 5 yards in their yard, but hit them further into the house? I mean, it's a 275-yard shot, right, to hit their house. That's a big hit, but golfers hit it that far.
Correct.
And is that, what isn't customary here? I'm just trying to understand, why was there a trial on this if your view is correct that the attendant circumstances and the deed language are clear?
Well, when the complaint was filed and up until the day the trial started, there were two claims that were being asserted. One was for trespass, which I think a motion for summary judgment probably would have been appropriate for, although it's a judgment call in my mind. The second claim was for nuisance.
Isn't nuisance easier to disprove than trespass?
I think it's easier to prove at trial, but I'm not sure it's easier to disprove as a matter of law, because it's the standard that gets applied, I think, is whether the reasonableness of the use compared with whether it affects the ordinary sensibilities of the homeowner. And I think the way I read it, it's potentially an issue of fact.
That means something to me, the way you read it. Does that mean then you agree that the language in section 20 or in 16 can be subject to an ambiguity issue in terms of interpretation? Is it ambiguous?
It's 20 ambiguous, I think.
Ambiguous, is 16 ambiguous?
I think there's a little bit of ambiguity in that recourse to the surrounding circumstances, the attendant circumstances. When it was being adopted, the course hadn't even been constructed yet in 1999 when the original declaration.
But do you think that they intended that this express language in section 6, do you think that what they actually, you say we want to know what the developer had in mind, did they actually have in mind that the balls are going to go so far that they're going to hit people's homes?
I think that's what happens when you buy a house adjacent to a golf course. There's no magic elixir that you can put on golf balls to stop them.
And this neighborhood, it's a necklace of these stately houses tightly bound around the golf course, right? Was that in the original plan too? I mean, it wasn't like there was a lot of room between the golf course and the houses. They're right along these fairways, right?
They are immediately surround the fairways. It's a golf.
Them, right?
There's 50 of them.
Are 50 houses up and around the fairway here?
I think they're close to the fairway. They may be closer to between 35 and 40. Mm-hmm. But there are houses on this golf course that the improved portion of the home goes right up to the boundary of the golf course, mm-hmm. which means you can't have golf, if this ruling is correct, you can't have a hole where any balls go on on that property because it's all improved.
It seems more complicated than that. Let's just say that you're absolutely right. Subsection 20 of the original declaration applies. And let's condense it down, that what that says is the right to operate a golf course, okay?
Yes.
So you've got somebody who's behind the 15th hole, somebody's on the side of the 17th hole. This is a dogleg left. The house is where it is. It's not like, every few rounds, somebody hits something into their yard. You're having, on the improved area of the lot, according to the light most favorable to the plaintiffs, these golf balls coming in and hitting the house a little more often than periodically.
Once a month.
Isn't it possible, well, for the windows that break, isn't it possible that you could be right that subsection 20 of the declaration applies and the unimproved is not a limitation, and still as a factual matter that there could be a trespass, and that's why there was no summary judgment?
Well, that's not my understanding of what easement law is interpreted as meaning.
Well, if it's
Law
ambiguous.
means, you can hit the house as often as, and there's no responsibility at all as far as the placement of the tees or anything like that.
I think, again, if you look at the Georgia case that we cited, which you can say is distinguishable because there's more of a specific reference to unintentional
Right, they specifically included the language about unintended ball hits or errant balls or misses, which we know are frequent.
I understand.
They include that.
But if you look at that case and get beyond that, the second thing that was argued in that case by the plaintiffs unsuccessfully was that the mere volume of balls that were hitting the house, and in that case, in 10 to 15 balls a day were hitting the house. We're going into the yard. There had been multiple occasions of the frequency of balls hitting the house was substantially higher, and this is over a 2.5-year period that we're talking about. They had dented the trucks, and they said that the mere volume exceeded the scope of the permissible easement. And the court in Georgia, and by the way, Georgia law and Massachusetts law are not, ridiculously different.
Counsel, I know that you're over time, and so with the chief's indulgence, I have a question about any limitations that you see to the easement in section 20 of the original declaration, because as I read it, it's reserving an easement to operate a golf course on lot 80.
Correct.
Right. So all this discussion about what's the natural and understanding of how golf is played is largely irrelevant under your literal reading of section 20 as an easement to operate a golf course on lot 80, right? Because if you can operate a golf course on lot 80, there are no limits really to the errant ball flying over lot 80, right?
No, we can't put a green on the house. We can't put a tee on the house.
But yeah, that's my question, I guess, is what are the limits that one would read into section 20 if one can operate a golf course on lot 80?
Well, the things that are a natural part of the golf course, which would be, for example, okay, we need water to irrigate the golf course. We want to drain the roads into the pond to irrigate the golf course. We need a drainage easement across the lots to get to the golf course.
Would usual and customary include literally putting the flag right next to their house? I take it that would be pushing it a little, right?
I don't think we have the right to change the operation of the golf course. I think we just have the right to operate the golf course the way it was built.
It means that they can operate it as a golf course. They couldn't have tent parties at 3 o'clock in the morning next to these people's houses, correct?
Correct.
It's a right to have golfers tee off and do what golfers do.
Right. And we don't have the right to retrieve the golf balls either.
Right.
It's just the golfers who do. They have the exclusive right to do that.
So before you wrap up, because you are out of time with the chief's indulgence, please, I just would like to ask you about the other issue, and that is whether this should have gone to the jury. And you're saying that it really is a question of law, the interpretation of the easements?
Well, I believe the case law establishes
All
that
right,
that's
but
the
that
fact.
was not, when the judge gave his instructions, there was no objection to this, correct?
There was.
There was? Where?
I filed a supplemental jury instruction saying exactly what I wanted the judge to be told.
But after that, you didn't object. Isn't that true?
I didn't object. I had to ask the judge to give some kind of an instruction. He refused, in his initial instructions, he told the jury nothing. So
I
we went to
understand, but
sidebar, and I basically said, can you please tell the
They
jury?
say you didn't object. You push all along for having a different interpretation. You push all along, but then at the last second, you don't say, I preserve my objection, right? You fight this pretty steadily. You file a motion for a directed verdict. You argue, you ask to be able to do a bunch of things, but you don't object to the last bit of this, right?
I think you could say that I gave up.
Right.
Can I ask you one more question?
Sure.
So I know Section 20, gives you the right to operate a golf course on Lot 80, and because it's not one of the enumerated lots in the declaration, right?
It's one of the
It's
lots
not.
referenced as not being subject to the original
Right,
declaration.
so it's not enumerated in the declaration, but then in the amendment, it becomes an enumerated lot. It's identified. And I'm wondering how the amendment, now having identified Lot 80, affects our interpretation of Section 20 of the original declaration, if you could follow that. Does that, you look puzzled?
I don't think I think you look at the language in the amendment, it says that all the provisions in the original declaration remain in force. So
Right, and one of the original provisions of the declaration is the Section 20, which is the right to operate a golf course on Lot 80. But now Lot 80 is expressly subject to the declaration as a golf course lot.
Well, no, I think the clear intent of it was, the clear intent of the two documents is just to clarify once the golf course was actually constructed. In 2001, now we know what lots are actually adjacent to the golf course.
So now we do know that Lot 80 is subject to the declaration.
I think Lot 80 is subject to the declaration. I think if you look at the rules relating to general plan developments or common scheme developments, the fact that a lot of lots were excluded, the original lot owners can enforce all those restrictions in the declaration of covenants and restrictions.
But, so that's a problem for you, because if Lot 80 is subject to this declaration, then paragraph 20 doesn't allow a golf course to be operated on Lot 80.
I respectfully disagree with that interpretation of
isn't it actually-
Section 20.
If you read it literally, you weren't expressly subject to it before. So you are in the sort of zone of land that's, covered by the golf course. Then when you're expressly added later, that doesn't put you within 20. It just means you're expressly included now. Those can be read together, I think.
I think they can be read together too. And we're just trying to be, the amendment is just trying to be more specific and trying to say things that there might be a fight over. Can you have a pool in your backyard? The amendment says no. Can you have a play set in your backyard, a swing set and whatever?
You thought it was obvious that you can run a golf course and hit golf balls out of bounds, but you didn't quite say it, but.
Well, I think the amicus brief covered that for me, hopefully.
Okay, thank you very much.
Thank you.
Attorney Galvin?
Good morning, Chief Justice and Associate Justices. May it please the court. My name is Attorney Robert Galvin. With me is Attorney Riley, and we represent Erik and Athena Tenczar. Your Honors, we believe that the motion for directed verdict and judgment notwithstanding the verdict were correctly decided because the covenants and restrictions, by their literal terms, do not authorize trespass, permit the plaintiff's home to be continuously damaged by errant golf balls.
Can I ask, what is are they allowed to operate a golf course in the customary and usual way? Is that your?
Not on the Tenczar's property, Your Honor.
Really? How is that possible? then I take it that applies to every property next to, there are 50 homes surrounding this thing, right? They're all built around the fairways. It's a golfing community. I don't understand how you can say that they can run a golf course, but they can't hit golf balls out of bounds. They can only hit golf balls in, I understand the golfers should not be going into their house or up to their windows. That's bad. And that was what they expressly dealt with. But isn't the whole purpose of this community and these declarations to create a golf course surrounded by these homes? And if you buy a house there, it's clear golf balls are not going to stay online. They never do. They never will. You know, it just.
So, Your Honor, I agree that my clients bought a home next to a golf course. I think that was plainly obvious, but what isn't plainly obvious, and maybe it's a little bit more obvious from the photographs in the record, this house was 200 feet from the fairway. There was a treed buffer between the rear of my client's home and the golf course.
Interpret the declaration. Tell us how those declarations about the customary and usual operation of golf course don't apply to your clients. Can you walk us through how
I can, Your Honor.
Yeah, go ahead.
I think when you have the original Declaration of Covenants, there are 34 some odd lots that are expressly subject to these 20 enumerated restrictions. The remainder property that wasn't subject to those restrictions, the developer has the right to build a golf course on, operate it, maintain it. I don't dispute that occurred at all. Then what happened is 4 lots were sold off to the golf course entity, the defendant in this particular case, and they built the golf course and its related facilities on those 4 lots. Then they amended
But the first one, developer expressly reserves and retains for itself the right to create, operate, and maintain a golf course on all the portions of the land as shown in the plan, other than those expressly subject to this declaration. So they are allowed at that time to operate a golf course on the property that your clients are going to buy, right?
Yes, Your Honor, I agree with
At
that.
that point, they're covered, clearly.
Right, because the golf course wasn't even designed. They left an interior
Well,
very
it's
large.
not because the golf course wasn't designed, it's because paragraph 20 says so.
Yes, Your
So
Honor.
what happens in 2001, in your view?
In 2001,
Yes.
the covenant is amended, paragraph 16 is rewritten. My client's lot is now a golf course lot. It's not a lot that you can operate a golf course on under the original declaration.
But it says, the amendment says the golf course lots, which includes Lot 80,
Correct.
are also subject to the following. Not only subject to the following, but also subject to the following. And so I'm wondering how, as a legal interpretation, you're saying Lot 80 is no longer subject to what it was subject to under the declaration, which you agreed was the right to operate a golf course on Lot 80 itself. But that this somehow limits what can happen on Lot 80, even though it has that word also.
Well, Your Honor, the language of the last phrase of paragraph 20 now takes, when you read these documents together, takes this golf course lot expressly out of that land upon which you can operate, create, and maintain a golf course. I think that's the only logical reading of those documents. And I agree.
Even though it seems like they're trying to do the exact opposite of what you're saying, which is to put tighter restrictions on those lots because they're right in the line of fire next to the fairway. And that's why Justice Wendland's point about also makes it complete sense that.
Well, we also have the language of subpart A. The developer has the right to reserve or grant easements for the benefit of the owner of the golf course.
But that's the language of easements are written in. Reserve the right creates the right. It's not.
Well, the evidence in this case was there were no other recorded covenants or easements.
But there's 20.
Yeah.
Excuse me?
There's 20.
Section 20?
Yeah, section 20.
But to read those two documents together logically, and I think the way it's properly read is once the amendment is on, this lot is now a golf course lot. It is not part of the golf course anymore.
It's now more restricted. There are more restrictions in play Meaning you're building a house next to the golf course. They're creating these additional restrictions saying, don't put a pool in there. Don't put outdoor furniture out there because basically you're going to get hit by golf balls or you're going to make noise and disturb golfers. But at the same time, you're saying the ordinary and customary operation of a golf course no longer applies?
Well, Your Honor, read literally, or, I mean, if taking it that way, my clients no longer have a right to have a house there if
No, they have a right to a house. They have a beautiful house next to a golf course that's not, 6 months of the year there's no golf or whatever there is. Then there are golfers and it's 270 yards away. You have to hit it high over trees. And how many balls are going in there now a year? How many are hitting the house? I understand there are going to be balls rolling into their yard.
Your Honor, they did.
How many are hitting the house at this point?
Well, Your Honor, in the last 3 months, we've had 10 balls.
Hit the house.
And that is,
Is that in the record? How many are in the
no,
record?
that is not in the record because this is all in the last 3 months.
What about the record? What does the record evidence
The
show?
record showed 651 golf balls were
How
hit.
many are hitting the house of the 651?
I'm sorry, Your Honor, I don't know the exact number. Roughly 100?
So in 3 years, 100 golf balls have hit the house.
Yes, Your Honor. Okay. In any event, I think that
And just roughly, is the record contain how many people play this course?
I think there is some evidence of how many people play coming from the golf course owner or the golf pro.
So we've got 30 balls a year hitting the house. Is that what we've got? Sorry.
Well, Your Honor, at the beginning, you recall there were no changes made to the golf course, but during the context of this litigation, there were some changes that were made on the golf course, presumptively to diminish the number of balls. So I think that there were more at the beginning and lesser at the end, but still far more than an occasional errant shot.
Can I ask the other question? So in your view, we look at only this particular easement, that golfers can collect their ball in the yard, but they can't go into the approved section.
Yes, Your Honor.
Doesn't that contemplate that their golf ball is going to be further in and the golfers can't get them? Or, I mean, because literally it's not possible, right, to prevent golf balls from going there, is there?
I don't think it's possible to contain all errant golf balls to a particular area, and some people could purposefully hit it
So how
wrong.
do they, well, golfers tend not like to hit the ball out of bounds.
Well, Your Honor, the evidence in this case showed that the hole was designed to be played in a way that the house and the yard area was outside this safety cone.
Right.
But what the evidence also showed was that when this golf course was constructed, the golf course itself
Well, it was outside the safety cone because there was a heavily wooded area, right?
No, the safety cone included a heavily wooded area when it was originally designed. The evidence at trial from the plaintiff's expert was based on an actual observation of people playing the hole, based on a website.
Are people trying to cut the dog leg?
They were, Your Honor. The hole is not as far as 275 yards to the house. It's shorter than that. To cut the corner, it's 210 yards. I think that was the evidence to get it over the sand trap at the corner. So people, that's not a long distance.
They changed the alignment of the tee box to stop that.
They
right?
did, and the website for the golf course that described how you played the hole encouraged people to hit it over the trap to the wide expanse of the fairway and the opposite side of the trap. And when you do that, the entire safety cone shifts to the left, and my client's house is located in the safety cone. And
Are you saying they're intentionally telling golfers to aim at the house?
I don't think they're intentionally doing it, but they intentionally put something on the website and said, this is how to play the hole. And when you do that, you're not playing the hole the way it was designed, according to Mr. Pascuzzo. You're doing it in a way that might be easier, but that...
Just a specific question. To cut the corner the way you're saying, how far do you have to hit it in the air to cut
210 yards to carry it over a bunker at the corner from the member's tee. And
as originally done, but then they moved it and became much further?
no, Your Honor.
So as it's currently designed, it's 210 yards to cut the corner?
From the original member's tee, which has been moved, Your Honor, it was 210 yards. to cut the corner. And, you know, the entire golf hole is just a little longer than 300 yards. You know, in the world that we live in today, this is, you know, reachable by
Can I ask a couple questions about the emotional distress damages?
Certainly, Your Honor.
And the damages in general. So your clients look to shatterproof, they look to whether they can buy stronger glass. And that costs $20,000, right? Something like that, or $40,000, I can't remember what the.
My clients, when the windows were broken, consulted with a company that was local here that did this type of repair work. And the testimony at trial from that witness was that the windows would still break. They wouldn't shatter with small shards of glass and spread it all over the interior of the home. But they would still break.
How many windows have been broken in
There's a graphic that shows that there's 8 bays of window with broken windows. Some have been broken more than once. They were double pane windows. But 8 total windows, all of the siding, the spindle or the balustrade on the deck, and the deck barrier itself have a hole in it. And the entire siding on that side of the house is falling.
So
But
then
Mr. Ga- I'm sorry, go ahead.
let me finish on the emotional distress. So there's $3.3 million in emotional distress or something like that.
3.4, Your Honor.
3.4, and there's, the evidence on emotional distress is basically, it's not medical evidence, it's the sort of descriptions from your clients of how they feel in the house.
Yes, Your Honor. There was no medical evidence. I agree with that.
And any quantitative evidence that we could tie the $3.4 million to?
I think that there was, Your Honor.
Well, what was it?
Well, Your Honor, my clients testified.
Right, but they didn't testify as to the amount.
There was no testimony as to an amount, and I didn't argue an amount to the jury.
So that where does the support for this number come from?
From the cumulative evidence, the testimony of my clients, who explained what it was like to live in that house, what it was like to experience a
And
ball.
what is the closest legal authority that you might have to suggest that such testimony is sufficient to justify the $3.4 million award?
Well, Your Honor, the instructions in this case, I think, gave the jury.
No, I'm talking about case law. What is your legal authority for the proposition that a $3.4 million verdict for emotional distress can be supported by the type of evidence that you decided to put in?
Your Honor, I don't have a specific case.
And isn't that a problem for you?
I don't think it is, Your Honor.
Okay, why
because I
not?
think we had a jury here that got a chance, and they were given the instructions to evaluate the impact of this activity on them for 4.5-year period of time. They gave firsthand stories of how it impacted them. Mr. Tenczar
So
testified.
what is your legal authority for the proposition that the jury can, given this type of evidence that was put in, come up with a number that they think is worthy of the emotional distress?
Well, I think the jury acted strictly in accordance with the instructions that they were given. And the instructions asked them to use their experience, their judgment, to avoid prejudice, to avoid considering.
Saying, Mr. Galvin, are you saying that this is not a negligent infliction of emotional distress, it's a trespass? And are you saying that with a trespass that you don't need a physical manifestation?
Yes, Your Honor.
And is there a case that supports that?
I haven't found a trespass case other than the Fenton versus Quabog case that allows an award for mental anguish, distress, and anxiety. That's the only trespass case that I found. But I did lump together my intentional tort of trespass with intentional infliction of emotional distress because I figured that was the closest akin intentional tort. And I think the case law is very clear in the case of that intentional tort that the physical manifestations that are required resulting from objective symptomology, I think is the negligent infliction standard, don't apply. And I think that's the right standard. And frankly, I think that
When you argued, did you give them, I haven't read the closing yet.
Yep.
Did you give them any kind of measurement devices, would you, I'm just trying to understand how they came up with 3.4.
I asked them to consider the impact of what had been going on.
And you didn't you didn't match it to numbers for different activities?
I purposefully did not do that, Your Honor. I felt that the jury who listened to the evidence should decide first of all, whether they believe my clients, okay? I think my clients were authentic. I don't think they went out and
Well, credibility calls are something that juries don't necessarily do, but and I think Justice Kafka are more concerned about where the jury was supposed to rest its decision to award your client $3.4 million.
Well, I think...
And it's not something that one inherently knows.
I agree with you, Your Honor. I don't think it is something that somebody inherently knows. I think it's something that you have to experience, you have to listen to, you have to evaluate the sincerity, the authenticity, the nature of the claims that were testified to by my clients, and the impacts. And, Your Honors, for the 4.5 years that this problem occurred at their property, there wasn't a moment during the day, during the golf season, when they knew a golf ball would not come into their house, through their windows, spread glass across their floor, or injure them.
And your position was that that was a surprise, having chosen to live next to a golf course?
Yes, Your Honor, because of the factual distance between the golf course and the improved area, which was significant. It wasn't right up next to the fairway here. There was 200 feet and a tree buffer. And furthermore, Your Honor, my client, Mr. Tenczar, testified that he knew, and by the way, there was an 18-foot retaining wall with a chain link fence on top, which actually gave the impression that there was a distinction between golf course and property. And I can't imagine anyone buying a house which they knew would be constantly destroyed or become unlivable because of this type of a condition. And if it was, like it was in the DeSarno case, that should have been clearly expressed in the documents, and it wasn't. In the DeSarno case, there was the additional exoneration or exculpatory clause that was in the restrictions. The homeowners could not sue the golf course owner.
Yeah.
Had those types of documents existed, it's very likely that the result would have been different, and the Tenczars.
Well, notwithstanding accounting for interest, or accounting for inflation, rather, in the Fenton case, they only got $2,650 in emotional distress.
Yeah,
This is really different.
Regretfully, Your Honor, I'm not a mathematician, so I thought about the present value of what that was today, and I honestly, I don't know if you took
I don't think it's 3.4
It's not $3.4 million. Okay, I concede that.
Wait, I take it you did a rough calculation. What is the rough calculation of 2,500 present value?
I honestly, that's why I said I'm not a mathematician, Your Honor. I couldn't do the math on that. But I do think that the jury listened to the evidence. I think they based it because we also had Judge White, who listened to all the same evidence, and he considered that. And if he felt that it was greatly disproportionate to the evidence, he could have overturned it, and he didn't. And he heard all the same arguments that you've heard, read all the same cases, and he saw the witnesses. Thank you, Your Honor.